Hello and welcome to Legal Thinking, the podcast from Royds Withy King. I'm Liam Pape.
And I was taking a drink of water. I'm Ed Wootton.
Hello Ed, how are you doing?
Refreshed now after my drink of water.
Good to hear.
Yeah, we got a really good one this week.
We have indeed.
Very brief as well.
Concise is I think, a better word.
Yeah.
We
efficient.
have efficient. We have a really interesting discussion this week with Jayne Martins, who is a partner in our family team, and it's about the new rules that have come into divorce law, and specifically the fact that you can now have a no-fault divorce.
Yeah, I'm sure it'll be very interesting because, not least people who want to get divorced, but just it's interesting generally, the fact that this has apparently been on the cards for years in some circles. So yeah, definitely worth a listen.
And it's the biggest change in divorce law in over 30 years. So without any further ado, let's roll tape. So, we'll start by just setting the scene, if that's okay. So, picture this. It's the year 2017. I'm sadly quite unhappy with my marriage and would like a divorce. Under what circumstances can I do this in 2017?
So 2017, you have a number of options available to you if you want to start divorce proceedings. You'd need to be able to demonstrate that your marriage is irretrievably broken down, and you'd have to rely on what we call a divorce fact to be able to do that. And that is adultery, unreasonable behaviour, desertion, which almost never applies, 2 years separation with consent, or 5 years separation. So you had 5 options available to you, 2 of which you could only use immediately, which would be the adultery or the unreasonable behaviour. Anything else you'd need to wait for. And certainly if it was by consent, you'd have to wait 2 years after you'd separated.
So on the 6th of April, new rules came in, and these allowed for no-fault divorce. In very basic terms, what does that mean?
Yeah, so now you can simply get divorced by saying that the marriage has irretrievably broken down without then having to rely on any of those divorce facts. So you just literally have to have a certificate that says that your marriage has irretrievably broken down, and that is enough for you to apply for your divorce.
Simple as that then. So does this make divorce easier? I think you've basically answered that one. So the second part of that question, I suppose, is will we therefore see an increase in divorces off the back of this?
Yeah, I mean, it doesn't, in terms of your first question, it doesn't necessarily make the divorce process easier. The divorce process is similar. In fact, it's actually longer now that we've got the new procedure in. The old procedure used to be able to get a divorce done in about 2.5 to 3 months if it was done fairly quickly. But certainly within 4 months, you'd usually be able to get to your decree absolute as long as both parties were cooperating. But now the new rules say that there has to be 6 months between the start of your application and the final order, which was the old decree absolute, because you can't apply for your conditional order, which was the decree nisi, for 20 weeks after your original application for divorce is made. And then you have to wait the requisite 6 weeks after that. So the whole period is now going to be 26 weeks. So it's slightly longer, but the process is similar. There's a petition. It can be jointly applied for by joint applicants. And then you have the procedure that's not too dissimilar to the previous law. So in that way, it is easier in that you haven't got to allege any fault or behaviour. You simply have to say that the marriage is irretrievably broken down. And I do think that will lead to more people considering it as an option. There's been a real problem historically with people having to cite behaviour or really make horrible allegations against one party where those allegations are unfounded and neither party really want to rely on those. But they've had no option if they want to go ahead and get divorced. So I have certainly seen clients now coming forward saying they now want to start the divorce process. They now want to start looking at finances now that the law has changed.
So just to jump in, would you say that you've seen a few people that, because you were in the little known publication, the Financial Times, recently, answering a question from someone saying that they wanted to divorce about 12 months ago, but were waiting for the law to change. Is that a common situation? Have you seen a lot of people kind of holding off until the changes occurred?
Yeah, I mean, I'm not sure how common it is. It's literally only just come in, but I've certainly seen people that have come in and said they have waited. I also did deal with divorces before the change where people were saying, they've got no option and they just wanted to go ahead and get it. But I certainly had about 3 or 4 cases that wanted to wait until the new law had come in. And even new clients that are coming in now are saying they've come in because the law has changed. So yeah, I certainly think there is a desire for it to have come in, and people are now considering it a viable option when they're separating.
Yeah, and an additional question that came up in that piece was whether it affects the financial outcome in any way. Does this change anything with the way finances are separated in divorce, or is it literally just the same as always? Is it easier?
Yeah, no, it's not. It's not really impacting the finances in a huge way. The divorce process and the allegations or grounds for divorce never really impacted on a financial settlement. So the new rules and the new law, it doesn't impact on how the finances would be divided. Our law in this country is very clear that finances need to be divided in a way that's fair and reasonable. So that's still the case. But I think it allows the parties to be more fair and reasonable anyway when they're approaching it, because they haven't got to take this difficult position where they are alleging behaviour or alleging a fault on one part. So it kind of already sets them on the path of being a bit more fair and reasonable with each other, and hopefully that will then follow through when they're dealing with the finances. So people that have held off getting divorced, as I mentioned in the Financial Times piece, it doesn't really impact on that. There are just some caveats about tax advice, that there may be some tax implications on holding off filing divorce proceedings, but that's a sort of specialist area that people can look into. But in terms of the divorce and how assets are shared out between couples, it's not going to make any difference to them.
Mm. And by sort of extension, does that then affect things like custody over children or anything like that with the changes in no-fault divorce, or is it literally just the grounds for divorce is the only thing that's changed and nothing else?
Yeah, it is just the grounds of divorce. So we don't really have custody in this country anyway. It's arrangements for children, which is now governed by the child arrangements orders under the Children Act, and they were very separate and distinct from divorce proceedings. And again, you wouldn't really rely on allegations in divorce within children procedures. But again, I think it's really important, and it's probably even more so important when you are dealing with children, that you get people to not throw mud and not allege behaviour where they don't have to. So it really sets them up to be able to deal with things much more amicably. Certainly where you can have joint applicants, they can both decide that the marriage is broken down and then both apply at the same time for the divorce. So there's no kind of one-sided approach to it. And then that can really impact on how parents communicate with each other for their children. If you're already starting off on the foot of having to say somebody's done something wrong, that's not a great place to start then discussions when you're talking about the arrangements for the children. So I think it will have a good impact for parents that are dealing with children arrangements, but it's not a sort of direct impact. Nothing under the Children Act has changed following this change in the divorce law.
Okay. Well, it sounds like divorce proceedings are all solved forevermore.
I
is there anything left to fix?
Yeah.
Well, to kind of turn that into a proper question, I was going to ask about the appetite. Sorry, not to insult your question asking style, lad. I was going to ask originally about the appetite for this change in the rules. And is this actually fixing a large problem, or are there still kind of larger issues that exist when it comes to getting a divorce? So, for example, you mentioned that this process is slightly longer, and in my eyes, but as someone who's never been divorced, the length, the fact that it takes 6 months, is that not an issue in and of itself that could be kind of solved or resolved?
It's something to bear in mind. The process itself is very similar. It's just because there's been this change and there's no allegations of fault, and they've also taken away the opportunity to defend a divorce. So you can't defend one now. If you're served with a divorce petition, you don't have the ability to then say, I don't agree to it, or I don't want to do it, which is why they've increased the time for 6 months to allow people to really have time to think about what they're doing, because once you've got that final order, the marriage has been dissolved and that's it. So it's really it's like the 14 days cooling off period when you buy something. They're kind of allowing a further a few weeks period of cooling off to just make sure you're doing the right thing, because you can't now defend it, and you can't, once it's finished, it's finished. So I think that's a good thing, because we're not justifying your divorce application in the same way. So you could just fire one off on the basis of your marriage breaking down. And it's right that there's some time built in there to allow a real thought to that. And also when you're sorting out the finances in the background, 6 months isn't unreasonable to try and sort things out anyway. So I don't think there are huge problems with the time itself. In terms of your original part of the question, is there an appetite for this? I think there's a huge appetite for this. And certainly I'm chair of Bath Resolution and a member of Resolution for family lawyers. And they've been lobbying for the change in the law for years and years. I mean, at least 20 years to try and get this changed. And it is the biggest change in divorce law that we've had in over 30 years. And it's a huge shift for us. And it just means that hopefully people will be able to be far more constructive in separation discussions involving children and finances, and just the divorce itself. It's not easy getting divorced. It's second to a bereavement. There's lots of emotions that go with it. And if we can try and ease that burden for separating couples, then all's the better. And the research is really clear when it's dealing with children that the only damaging factor to children of separated parents is conflict between the parents. And if this just goes some way in reducing that conflict or that potential for conflict, then it can only be a good thing. So I think there has been real appetite for change, and I think it will hopefully be able to set the tone early on a far more constructive level.
And just to clarify something, can this be made as a sole application, or does it now need to be joint, like wholly joint, to be a no-fault divorce?
Yeah, so you can do either. So you can have a joint application where both people just want to get on with it themselves and they're quite happy to have a joint application, which is very new. We've never dealt with anything like that before. There's usually been a petitioner and a respondent, and that's the way it is. But no, you can have joint applicants now. The procedure still takes the same amount of time and it's still a similar process, but you're just both applying for the same thing. And you can also switch. So if you start off as a joint applicant, you can become a sole applicant within that procedure if you need to. So if, for example, one of the applicants changes their mind or is not engaging in it, or just not filling out what they're supposed to fill out, a joint application can become a sole application. You can also apply as a sole applicant, which is much more akin to the traditional route, but you can't change a sole application into a joint application.
Got it. Ed, have you got any more questions?
I think that's covered everything I want to know.
Short and
Not
sweet.
that I need to know, just to be clear, see if my wife's listening to this.
Well, you never know. I'll give her my card.
Jayne Martins, thank you very much for your time.
You're very welcome. Thank you.
Thanks again to Jayne for joining us. Absolutely, really, as we said at the beginning, very efficient. Got all the key points across. I think it's just really interesting that although there isn't a change to the process for child arrangement, for example, just the fact of changing the divorce process itself has a benefit on children and families who are going through this process.
Absolutely. And of course, I wouldn't be able to forgive myself if I didn't plug Jayne's piece in the Financial Times that she alluded to in the interview. So to read that, you can go to our Twitter, which is twitter.com/@Royds Withy King.
Yeah, and from Monday, that'll be RWK Goodman. Yes, what you want to look out for. So yeah, very exciting times for us. Welcome to our colleagues from Goodman Derrick next week. If you want to hear more from Legal Thinking, make sure to subscribe. And if you liked the episode today, give us a rating. Otherwise, thanks for listening.
Thanks for listening.